Welcome to the Litigation Psychology Podcast, brought to you by Courtroom Sciences and Dr. Steve Wood. Excited for this podcast. That this is a topic that I've been getting into a lot more, and I'm excited to have our guests on today to talk more about it. And that podcast topic being deepfakes today. And to help join me to talk about deepfakes and talk about a lot of the other stuff that's going on as far as from a technology standpoint in the courtroom, I have Fred Lederer. Fred is Chancellor Professor of Law and Director of the Center for Legal and Court Technology at William and Mary School in Williamsburg, Virginia. Professor Lederer has a lot of areas of expertise: evidence, trial practice, military law, legal technology. And one of the main ones I brought him on to talk to about today is AI and how that has an influence in the courtroom. Fred is also an author of numerous books, and a few law education television series shows. So Fred, happy to have you on. Thanks for joining the podcast.
It's a pleasure to be here. Thank you for having us, Steve.
Yes. And now, one of my other hosts here, or one of my other guests here today, is Daniel Shin. Daniel is a cybersecurity researcher at the center, CLCT, as you guys refer to it, right? Center for Legal and Court Technology. Mm-hmm. Daniel, thanks for joining the podcast as well. I'm happy to have you on here to talk about deepfakes.
I'm quite excited to be here. Thank you.
Thanks. And, before we get started, really what I want to do is I want to talk about the center itself. What's the history of the center, Fred? I know it's kind of started off as something else and it's kind of morphed, but you guys are doing a lot of cool stuff there. So what's kind of the history of the center?
We've founded the Center for Legal and Court Technology, as you put it, CLCT, formally, which means there's a prior history as well, in August of 1993. In those days, we were the Courtroom 21 project, standing for the courtroom of the 21st century today. As the years passed and our activities expanded and we went to a new century, we became the Center for Legal and Court Technology. Briefly, our original primary focus was how to use technology to improve trials and hearings, civil, criminal, federal, administrative, and so on. And then as life went on, we expanded into the topic of the interrelationship between law and modern technologies, particularly artificial intelligence and cybersecurity. And I'd note that Daniel, who is, among many things, a research scientist here, is an extraordinarily knowledgeable and skilled expert on most of the technology subjects, as well as being a first-class lawyer.
And Daniel, so, as far as AI and all that stuff goes, what's kind of your experience? Are you able to, are you do coding and all that stuff too? Or what is your experience with AI and all of the different areas that it relates to?
Sure, Steve. I do know programming, and I use all the technical sort of knowledge to supplement research and studies. But with respect to AI, it's not like I craft an AI model from scratch. In a lot of cases, what happens is for a lot of the open source, publicly available models out there, such as on GitHub, which is a very popular code repository online, I'm able to download the model, download all the relevant code that interfaces with the model, and experiment with what AI researchers, usually at universities around the world, have done in terms of doing all the AI functionality locally on my computer. This is distinguishing from a lot of the AI services that you see online, like ChatGPT, which the OpenAI. You use those models by running it on OpenAI's model servers online. My focus is more on AI models that you can run on, personal computers, high-end personal computers sometimes, but that raises some interesting issues.
Now, Steve, please keep in mind that our primary focus is the legal and public policy implications of all this. So though Daniel is very, very skilled as a technologist, it's his ability to understand how this all works, how it fits together working with our other colleagues that allow us to do what we do, which includes, by the way, Daniel puts out a periodic cybersecurity newsletter, which your listeners and viewers are certainly welcome to ask for copies. Just send us an email. We also put out probably about twice a year an AI newsletter as well. This is all part of what we're doing.
That's excellent. And I'm going to talk more too towards the end of the podcast about all the other stuff you're doing. Like I said, I know you guys are doing a lot of things. The McLaughlin courtroom has a lot of stuff that we want to touch on as well. But I want to talk about deepfakes first, and then we'll make sure we circle back that, but I guess just generally for our audience who doesn't know what deepfakes are, Daniel, what are deepfakes? What are they, and what is kind of the background and history of it?
The current definition for deepfakes, I would say, is synthesized, realistic looking data, but that are simply synthesized or fake. And initially, when deepfakes started to really emerge back in 2018, and we actually were arguably the first law school to do a deepfake demonstration, when it was like a face swap type of a medium where somebody online and this person just devised a bunch of code, AI code, machine learning code that ultimately allows a user to take a face of one person and then paste it into a video scene of a different person in a very photorealistic way. And at that time, deepfakes were understood as a video where, using some machine learning technologies, somebody is able to paste a person's face into a different video, a target video context in a photorealistic way. But that kind of started the whole deepfake frenzy, so to speak. But it has expanded to other types of media. For example, we have seen a lot of instances of voice synthesis, text to voice synthesis, where you provide a text. And if you have a voice of somebody, you can have the AI model take attributes or characteristics of that target voice and produce an audio clip of the text using that person's voice. You can also have voice mimicry, where the AI model will mimic somebody speaking just based on pure audio. It also, I think, arguably, ChatGPT introduces what you consider to be text deepfakes, or there are instances where on Amazon, people generated fake travel books using ChatGPT. They're not real books because the AI model a lot of times hallucinates, or as they say, produces text that are convincingly real, that purports to say something truthful, but in fact, it is making up facts or it's fictitious. Finally, the most concerning part about deepfake, especially in the pornographic context, is the text-to-image AI models, where most recently, I think, Stable Diffusion is an open source model you can download on your computer and generate all types of images without any restrictions. And I mean all types of images. So deepfakes have evolved over time in the past couple of years.
Yeah, and I think it's worth noting, with apologies for interrupting here, that one of the more recent scams that apparently is spreading is the use of AI to create realistic but false voices, so that people, particularly older people, get calls purporting to be from their grandchildren saying, "Help, I need money," and the rest. And it sounds just like the child because they have found a sample of the actual voice, and then using the technology that Daniel just spoken about, is they have composed or had the computer compose this entire fake statement.
And I think that's one thing I want to talk about, Fred, because as we talked before we got on, in my experience with deepfakes has been more of just kind of a joking manner. Like there's a lot of them out there with Arnold Schwarzenegger, where Arnold Schwarzenegger gets put into all these different famous scenes and movies, but there's a lot more nefarious uses for it, as you talked about with the phone calls, the robocalls, and trying to get information. But I think there's other stuff too that Daniel kind of touched on. Do you want to talk a little bit about what are the other kind of legal aspects that have been emerging as it relates to deep fakes and evidence and how people are presenting that?
I think the dilemma that we're now facing in the legal system is that we know the technology exists. We also know that we are using audio and video in particular in what appears to be a huge number of our cases of all types. We often say, sometimes jokingly, quite seriously, in others, that almost nothing can happen in the current world without someone pulling out a phone and recording it. And then in court, Your Honor, it's all on my phone. I'd like to show it in one form or the other. And when we design courtrooms, that's one of the things we have to keep in mind. The question of the impact of all this has not yet really hit us. And there are two ways of looking at it, and I'll try to be brief. The first is from the perspective of the evidence rules, and I can talk about those if you have any interest. The second, which is far more important ultimately, is what happens when not just judges, but our population that will make up our jury pool, frankly, don't believe anything they see or hear. And it is quite probable that we'll be encountering that over the next few years. At that point, the burden of proof to convince someone that what they're seeing or hearing has not been composed by technology is going to be rather extraordinarily difficult.
Yeah, and I do want to talk about from an evidentiary standpoint. I think it would be interesting as far as admissibility, and that's one of the things, right, is whether the judge is going to allow the evidence to come in, or what kind of the federal rules of evidence or the rules of evidence are around that. I know some states have rules, some states don't. What are the kind of, at least from that evidential aspect, are they facing?
Well, under general, we have two different areas that come into play directly, and some others that are indirect. To authenticate evidence traditionally has been to show that this is likely to be what we say it is. In the language of Federal Rule of Evidence 901A, there is evidence sufficient to support a finding that this is what it purports to be. 901B has a non-exhaustive list of examples. The dilemma here is, how do you necessarily prove that something is what it purports to be? The classic traditional way, and the most used and simplistic, is a witness with knowledge. The witness says, that's correct. I saw it, I was there, this is it. That, of course, might be untruthful. It might be entirely truthful. It might be truthful and a mistake. Now, let me take a minute, if you have time, to deal with that.
Sure.
And this is something I don't think that most of us have thought enough about, but it may be that with your expertise that you have. Suppose we had a photograph of a scene and include an automobile with a license plate. We ask the witness to describe the scene, then we show you it's previously marked as Plaintiff's Exhibit 5 for identification. What is it? Oh, that's a picture of the scene. And is this accurate? Oh, absolutely. Unbeknownst to the witness, someone has used technology to change the license plate number. Very few people would focus in the real world on the license plate. They would be able to say, yes, this is the entire picture. We have now had a truthful witness mistakenly authenticate a photograph that contains critical but erroneous data. That could happen.
So, Daniel, I mean, what do you do in that situation? What is the courts? What are the attorneys? What's kind of if anything, what's the solution for that?
I think the immediate response will be is the importance of chain of custody of the digital evidence that's brought into court, making sure that the evidence, whether it's a picture or video, has not had an opportunity to be tampered with when it was first obtained. The issue that deepfakes present, however, is that somebody may have planted that evidence. If it was a security camera footage, for example, a skillful or a person with sufficient access credentials could have easily taken the original video, manipulated using deepfake technology, and then swap it, making sure there's no evidence of tampering. And then when the police collects the evidence or whoever, the chain of custody starts at the point of collection, but not at the point when the data was created. So deepfakes present an intriguing issue where I think under most circumstances, chain of custody may not be sufficient to fully authenticate the truthfulness of a collected digital evidence. I will just add, though, that it is not doom and gloom, even though if deepfakes are able to, and we're at a point, I will say, for image synthesis, for certain video synthesis, yes, there are certain AI models where you can write a description of a video clip and it would actually generate a short, bizarre-looking video. But down the road, we need to assume that we will have the technology to create indistinguishable media. Let's put that as a given. Is that the end of the world? No, because Adobe and other companies, for example, has devised ways to essentially authenticate the data at the moment of creation. So think about when you're taking a picture or you're taking a video footage, using hashing algorithms, which are basically ways to measure the characteristics of the data. Using hashing algorithms, when the data is first created, when you take the first photo or the video, you can embed a cryptographic proof that the data is what it is when it was created. And if somebody tries to alter the data afterwards, the cryptographic hash will indicate that data has been altered. So that movement of authenticating evidence at the moment of creation has been gaining traction in response to the unique threat that deepfakes present itself.
Fred, I want to talk about that too, because not only is it a matter of whether or not someone has actually altered it, but there's been a couple legal cases, and you can talk about them if you want, is, where defendants have actually said, this is a deep fake. I didn't actually say that. Tesla and a couple of the defendants in the January 6th Capitol riots, they basically tried to say this information or this data is deep fakes, right?
Yeah. If I recall, yes, I think Elon Musk, who is, I think, in the humor side of YouTube, is sort of the target of many deepfake creators, and I think that there's one Chinese YouTuber who deepfakes himself as Elon Musk, just for a humorous content. I think the problem is that when they made the claim that they were victims of deepfake, I think the technology to create such indistinguishable media was not widely available. And just to be clear, whatever deepfakes we're talking about, they take a lot of computational power. In simplest terms, you're talking about buying a personal PC with a GPU, which is a graphical unit processor, mostly used for producing 3D graphics or gaming on a PC. At a minimum, it's going to be over maybe $1,500, just off of my top of my head. You need to have expensive equipment to generate really good looking deepfake media as a given, or you can't do it. Yes, you can use cloud computing, but that requires additional technical knowledge. So a lot of those earlier allegations that whatever evidence that's been presented against the plaintiffs, that the evidence is a deep fake, I'm a little bit skeptical on that front. One other data point that I can provide is allegedly Russia-affiliated groups online produced a deepfake video of the Ukrainian president, President Zelensky, about something about surrendering to the Russian forces. The video is basically combining the voice deepfake of President Zelensky speaking, "We should surrender to the Russian forces," as well as matching the lip movement to match the synthesized audio. Was the video convincing? Absolutely not, because whoever created that deepfake first didn't have the computer equipment or the resources to do it, but second, they were really not experts at creating the data. Moving forward, I think that changes the game, but retroactively looking in the past allegations of deepfakes, I don't think people had access to the expertise and the computer resources to create that level of convincing deepfakes.
It's probably worth noting that, speaking as Daniel's favorite guinea pig, it is possible to do very persuasive, convincing fakes. It's not clear to me that it's necessarily helpful, but it might be to just note that at least up to the moment, we are actually replicating what's been going on in the legal system for literally generations. We have had expert forgers in existence as far back as we've had writing. And I've never bothered to look up a case, but undoubtedly they're there in any number, where individuals claim that important writings dealing with contracts and property and so on had been fabricated or altered in some important respect. We certainly knew we had people who could imitate people's handwriting flawlessly. However, the number of people who could do this and do so accurately and well enough and were in the right place at the right time were relatively few. That's pretty much where we are at the moment. The technology is easier, if you will, to obtain and use than the number probably of expert forgers used to be. But right now, someone like Daniel and many others have a reasonable chance of being able to detect what otherwise might be a fairly persuasive deep fake. Our dilemma is this is not likely to continue. In the future, we are likely to get better and better false exhibits, and it will become increasingly difficult to determine what the truth is if we do not have other evidence of contents. And that's going to be a problem. And if we ever reach quantum computing properly, then that may simply mean we won't be able to ever tell the difference.
And that's what I wanted to talk about too, is Fred, as far as from a juror's perspective, because a lot of jurors, as you said, every time something happens, people pull out their phones, and I guess the question is then, how do attorneys, how do judges, how do the legal community moving forward, like what is it then that they should be doing, or what is it the things they should be focusing on to make sure that they're authenticating evidence and that they're making sure they're explaining to jurors about this kind of concepts of deep fakes? I mean, it sounds like there's a lot of education that needs to go on first, but what is kind of the going forward?
I think you've just summarized the situation. Without quoting the individual, some years ago, a representative of a major technology company came to us, and we've never let him forget what he said. And the verbatim quote goes, "As we understand it, most judges and lawyers don't understand much about technology, and worse, they're proud of it." And based on our experience in law school, most of our law students know very little at all. Only yesterday, I asked one of my classes, as I often do over the year, can anyone explain to me how email works? On average, I get 1 to 2 people out of a class who will put up a hand, and when called on, they generally can't explain. So our first problem is that we need the legal community to spend more effort than they have done in the past to understand the technology, understand the weaknesses, know when and how to look for people to determine, help them determine if this is real, and help them to prove it or disprove, as the case may be. Secondly, of course, it appears, at least to me, that we are going to have yet again an increased emphasis on eyewitness testimony in the hopes that we have the ability to determine whether the witness is being accurate or not. That, again, is an area of expertise that you have. Personally, I've never had much faith in demeanor evidence, either as a trial lawyer or as a trial judge.
Well,
but that's a different topic.
Well, I think it's interesting that you do talk about having more faith or having to rely more on witness testimony. I mean, but then at the same time, if you have a video that shows one thing and you have your eyewitness that's saying that's not how it happened, it's like, well, or that's not who that was. You say, well, here's the video. Then you have a problem with that too, because now you have humans that can lie, but also now you have computers that can lie.
Yep.
So
isn't it a wonderful new world?
It is. It's a wonderful new world. So I guess, Daniel, we talk about it. It's all not doom and gloom, but I mean, I guess, is there things that are currently being done right now to help with that, as far as any sort of litigation, or whether there's any laws that are being made to kind of help with this?
I think the issue is less with law at the moment. The key to kind of being resilient against this, evolving issue, I wouldn't call it a threat necessarily, because there are some positive applications of deepfakes, although they may be narrow, is combating against misinformation about deepfakes in the first place. I think a lot of people who raise the issue that certain evidence presented against them, for example, were, a product of a deepfake creation, don't know what they're talking about, or cannot, at a minimum, identify what tools or what processes have been used to create the deepfake, evidence presented at trial. There is a lot of complicated process. There's a lot of algorithms. There's a lot of data that's involved in creating all these deepfake. And as you kind of explore the world of how do you create a face swap video, or the photo, or photos of things or persons, you start to appreciate the immense amount of work that academia put into this technology, but also you recognize the limitations of these deepfake tools. The reason why deepfake have developed rapidly over the years, and it seems to be this unstoppable force, is because a lot of these tools and these algorithms is overtaken by open source developers who are very enthusiastic about the technology. So they're constantly identifying certain limits about these deepfake tools and trying to overcome it. Ways to become resilient against this trend is to be aware of what are the current limitations of these deepfake tools, and use that to really know how to start spotting, or what are some of the problems these tools exhibit. For example, stable diffusion, which is a model where you can provide a text of an image you want it to generate. Stable diffusion is really good at generating photorealistic images, but one of the initial problem it had was it was bad at generating hands. People who are listening to audio, I'm just presenting my hands. I have 5 fingers each. But stable diffusion, the 1.5 model, had sometimes generate 6 fingers, 4 fingers, or sometimes, is that really a hand? because there's some inherent limitations in the model. It has been rectified, but all I'm saying is if you start learning about how these technologies work, not at a technical, super technical level, but knowing also the limits of these technologies, then we're not at a fog of war. You kind of know the landscape of where this issue kind of lies ahead.
You know, Fred, are you teaching your students that there at the law school? As far as, I mean, is it like a full-on course, or is it just kind of integrated into courses, or what?
It all depends on what we're talking about. We're trying to integrate basic technology into the relevant courses. We have a specialized course that we and one of our colleagues, Professor Iria Jafrida, with Professor Nicholas Vermees from the University of Montreal, created, called AI and More. Daniel is teaching what I think is probably a unique course in a law school, which is the technology of AI. It's a course he's about to launch. And of course, in our case, we teach what we call technology augmented trial advocacy, which is a trial advocacy course that not only includes the classic basics on how to try a case in a classic courtroom with no technology, includes everything up to and including holographic evidence at this point.
And I think that's
So
actually,
we're doing our best.
well, I think that's actually
Sorry.
a good segue. I do want to talk about, as I said, and we mentioned at the top of the podcast, that, you know, CLCT is doing a lot of cool things as far as not just the deep fakes, but you guys have this kind of courtroom, this new gen courtroom, right? You want to talk about that a little bit, Fred, about the courtroom and all the technology you have?
The law school includes what is called the McLaughlin courtroom, which is generally regarded as the world's most technologically advanced trial and appellate courtroom, which is quite literally accurate. In fact, some years ago, I was in Seoul, and a justice of the Korean Supreme Court told me that all the South Korean courtrooms with technology were copied from us in particular. And the courtroom was in particular, of course, not in use during COVID, and now we're rapidly working to upgrade it. But our technology includes things such as far as we know, we have the world's only capability to have life-size, three-dimensional, remote holographic witnesses, participants, evidence. Yesterday afternoon, as we were continuing our upgrade process, courtesy of I should say that the hologram is made possible by a company called Proto. And yesterday afternoon, colleagues from FTR, which is the world's largest court record company, were giving us the ability to have an AI-based automated speech-to-text transcript, which when you click on a word on the electronic transcript, you immediately can go to the audio and the video as well, which gives you 100% accurate. So we've gone doing our best to ensure that we have modern technology, including, for instance, technology for people who have difficulty seeing, moving, hearing, and far more. Accessible technology is critically important to keep everyone able to have their day in court. It also makes it possible for those who cannot see, cannot hear, to be judges and lawyers and so on. So that's our courtroom. We're very proud of it, and we spend a great deal of effort trying to keep it at the cutting edge.
You know, a couple of follow-up. I mean, are actual trials being held there? This is not mock trials or any of that type of stuff. I mean, are you actually holding trials?
We have done experimental cases with sitting federal district judges and such. But as you know, the difficulty of moving an actual case, including a jury, is rather difficult. We have had a number of administrative hearings in the courtroom, without naming a rather prestigious agency/court from Washington. We're in discussions about they might come down and actually hold a real case with a remote holographic participant from another country. but we are largely limited to experimental cases, or of course, cases we're using with our own students to help teach them how to best use this.
Yeah. So I'm going to talk a little bit. I mean, the holographic evidence or the witness, I think, is very, very cool, very interesting. How does that, Daniel? What's the technology behind that? Like, how do you do it? You got to go and set up a camera at the person's house. Like, how do you even project that person holographically into the courtroom?
Certainly. So there's two components to make this work. One is what we call the beaming station, or where the video originates, and that gets transmitted into the second component, which is the hologram component. And in essence, uh, a very high quality video footage of the person beaming into the hologram gets prepared. A very high quality camera uh, that is shot in 4K. And the 4K video gets directly transmitted into to the to the hologram device, and people who have been Zooming or team video meeting will be very skeptical. And I was skeptical myself. It's like, well, it's just a bigger video transmission device. What's so great about it? And the combination of resolution, the quality, the color, saturation, because the person is usually at a white background, the white backgrounds kind of tends to key off, or just like in the weather, when you're seeing a weather forecast, the meteorologist is in front of a green screen. Imagine there's a white screen behind it. That gets blended nicely into the hologram to a point where it really appears as if the person is inside the device and interacting with it. Because it's a full body projection for witness testimony, for example, you get to see whether if the person is nervously, twiddling their thumbs, for example. You can read the whole body language for remote evidentiary purposes. So it's one of those, I hate to say this to people, but it's one of those things where take a look at it and judge for yourself. I'm continuously impressed by it, and it may have a greater role in our legal system.
It may be that for those of you reviewing this, that we're at this point showing the picture, but as far as the origination, it should be noted, at least the company Proto says that it is possible to originate just using a cell phone. Our experience has been a fair amount of light is desirable. And of course, you want your remote individual to be able to see what's going on in the courtroom. So we also display the image from the courtroom on a flat panel in front of the individual. All of this, of course, is dependent on the internet. So the information goes to a server, which I believe is in Los Angeles as a rule. And from there, it goes to wherever the courtroom is, which in our case is in Williamsburg, Virginia. The individual, if this is a person, I'll get to that in a second, appears in what we call an epic, which looks like, if you're not seeing a picture, a rather large phone booth. And the individual, as Daniel says, is available life size. And from our experience, is pretty much the image is not different from watching the human being in the witness stand. I think for demeanor evidence purposes, pretty much the same. Now, from a legal perspective, I'd note this is a fundamental question. As most lawyers who are listening or judges, pursuant to the Sixth Amendment's Confrontation Clause, it is customarily unconstitutional to have a remote prosecution witness. No problem with a remote defense witness. Now, this is in criminal cases. The argument that we think we can make is that given this technology, a remote holographic witness is for all practical purposes the same as being physically in the courtroom, if we do it right. Should the Supreme Court ever accept this argument, that would open the door to fully remote criminal cases. Now, of course, for civil cases, we don't have a Sixth Amendment issue. On the other hand, we certainly have the interest of counsel in winning the case, and this is particularly persuasive. Now, it's not just human beings, whether they are witnesses or counsel, because you can also have your evidence presented in this. And the company, in fact, has a much smaller and thereby cheaper unit called a mini, which has been used, for instance, to show incredibly expensive paintings at auctions. You can read about this in the Wall Street Journal and other media. And that means we could have 3D evidence right in front of a jury without them having to physically handle something, which also would give the potential ability to give that to juries during deliberations. So we're not yet sure what the limits are of this technology. We're hoping that in the year to come, we'll be able to do some proper experimental work and see what's the relationship between how jurors would react to a in-person witness versus Zoom versus hologram.
Yeah,
and as they say, probably stay tuned.
Yeah, and I definitely want to have you guys back on for that, because you read my mind, because I was going to ask, whether or not you'd done any research on what jurors thought about the different variations of, witnesses, and whether or not they see a holographic witness as the same as someone who's actually in person, or if it still has that disconnect between like what we have through Zoom and other aspects.
I could tell you, by the way, that years ago we did do what I think is the foundational research in remote witnesses. Now, what we do in our particular experimental design was we assumed a civil case. We assumed we needed an expert witness, a medical doctor. So what we did is we had the medical doctor either in the courtroom or remote. We weren't using anything like Zoom. We were using high-end video conferencing technology. So we had the witness life-size on a flat panel right behind in the witness stand on the wall. And what 2 years of controlled scientific research indicated that so long as the witness was life-size in the witness stand, we got exactly the same result out of the jury as we did if the doctor were physically in the courtroom. Now, we did a civil case, and we did that so we could quantify by jury verdict what the impact was. Now, this was years ago. We'd feel a lot more comfortable running it again, and hopefully we will. But that's also why a fair number of courthouses, especially in the US, follow our general design, which is large flat panel right behind the chair where the physically present witness would testify. Now, by the way, we never did the research to determine what happens if you roll a TV screen into the middle of the courtroom or something. We don't know what happens there. We do know that our particular design seems to work.
There you go. Now you got some more research on your hands than you do, huh?
Right.
All right. Well, I'm not going to keep you any longer. I appreciate it. This is a fascinating discussion. I could have gone on for hours talking with you guys, but I do want to let you go. First, Daniel, if anybody wants to reach out to you and talk to you more about this, about AI and about deepfakes, how do they get a hold of you?
Sure. First, I'm on LinkedIn, although there are a lot of Daniel Shins out there, and we are an amazing group of people, maybe because of our name commonality.
Probably, yeah. I met a Steve Wood the other day, actually. So
fantastic. I'm on LinkedIn. As Fred mentioned earlier, I write a monthly cybersecurity and information security newsletter, which also gets shared on LinkedIn. Please feel free to sign up if you're curious about. I do cover AI, but I write it in a way that is very accessible for non-technical audiences, or at least I try to, and dive into some legal issues of the story that I cover. Also, and Fred will mention that we have our CLCT website, which is legaltechcenter.net, where you can find all of our portfolio of work, announcement, news that people can definitely check us out.
Yeah, I do. I would say check that out. I took a look at it. I think there's a lot of interesting stuff up there. It talks about CLCT and all the great things you guys are doing. What about you, Fred? How do people get a hold of you if they have questions, want to talk more, want to probably have you come speak a little bit more about all the expertise you have?
We, of course, are part of William & Mary Law School. The Center for Legal and Court Technology is a joint initiative of the law school, which is the oldest law school in the country, by the way, along with the National Center for State Courts, which is physically right next door to us. So besides the email address, which is filede@wm.edu, all you have to do is do a quick search for either CLCT or Letterer at William & Mary, and you'll find us.
Excellent. Like I said, once again, greatly appreciate both you guys coming on. Fascinating discussion. Probably have you touch base, have you come back in a little bit. Once you have some more information, we'll talk more about the research and all the other excellent things you guys are doing there at CLCT. So I would encourage everybody to go to courtroomsciences.com as well. Our podcasts, our articles, other aspects up there as it relates to anything litigation psychology. This has been another edition of the Litigation Psychology Podcast brought to you by Courtroom Sciences.